ನಮಗೆ ಒಂದು ಇಂದು ಉಪನ್ಯಾಸ ನೀಡಿದ್ದಾರೆ ನಮ್ಮ ಸಂಘದ ಹಿರಿಯ ಸದಸ್ಯರಾದ ಹಾಗೂ ಹಿರಿಯ ವಕೀಲರಾದ ಶ್ರೀ ಪ್ರೇಮನಾಥ್ ಸರ್ ಅವರು. ಅವರನ್ನು ನಮ್ಮ ಅಧ್ಯಕ್ಷರು ಬರಮಾಡಿಕೊಳ್ಳಬೇಕಾಗಿದ್ದ ನಮ್ಮ ಸಂಘದ ಅಧ್ಯಕ್ಷರಾದಂಥ ಶ್ರೀ ಶ್ರೀರಾಜೇಂದ್ರ ಇವರನ್ನು ನಾನು ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಸ್ವಾಗತಿಸ್ತಾ ಇದ್ದೇನೆ. ಅದೇ ರೀತಿ ಇಂದು ಸಂಪನ್ಮೂಲ ವ್ಯಕ್ತಿಯಾಗಿ ಆಗಮಿಸುವಂಥ ನಮ್ಮ ಹಿರಿಯ ವಕೀಲರಾದ ಶ್ರೀ ಪ್ರೇಮನಾಥ್ ಸರ್ ಇವರನ್ನು ಹಾರ್ದಿಕವಾಗಿ ಸ್ವಾಗತಿಸ್ತಾ ಇದ್ದೇನೆ. ಇವರಿಗೆ ನಮ್ಮ ಅಧ್ಯಕ್ಷರು ಹೂಗುಚ್ಛವನ್ನು ನೀಡಿ ಸ್ವಾಗತಿಸಬೇಕು ಕೇಳಿಕೊಳ್ತೇನೆ. ಸಮಯ ಬಂದಿದೆ. ನಮ್ಮ ಸಂಪನ್ಮೂಲ ವ್ಯಕ್ತಿಯಾದಂಥ ಶ್ರೀ ಪ್ರೇಮನಾಥ್ ಸರ್ ಅವರು ವೇದಿಕೆಯನ್ನು ತೆಗೆದುಕೊಳ್ಳಬೇಕಾಗಿ ವಿನಂತಿಸ್ತಾ ಇದ್ದಾರೆ.
ಕನ್ನಡ ಮತ್ತು ಇಂಗ್ಲಿಷ್ ಎರಡು ಮಿಕ್ಸ್ ಮಾಡಿಕೊಂಡು ಮಾತಾಡ. ಇಷ್ಟು ವರ್ಷಗಳಿಂದ ಇಂಡಿಯನ್ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ನ ಬದಲು ಇವತ್ತಿನಿಂದ ಹೊಸ ಕಾನೂನು ಜಾರಿ ಆಗ್ತಾ ಇದೆ. ಆ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ನನಗೆ ತಿಳಿದಷ್ಟು ಮಾಹಿತಿಯನ್ನು ನಿಮಗೆ ಕೊಡಲಿಕ್ಕೆ ನಾನಿಲ್ಲಿ ಬಂದೆ. ಸೊ ಫಸ್ಟ್ ಟೈಮ್ I congratulate our President and Office Bearers for doing this kind of classes to educate their work. As far as the Evidence Act is concerned, the name is changed. ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮ BSA, ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮ BSA 2023 ಇಂದ ಹೊಸದಾಗಿ ಆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಇದರಲ್ಲಿ ಒಟ್ಟು 170 ಸೆಕ್ಷನ್ಸ್ ಇದೆ. ಓಲ್ಡ್ ಆ್ಯಕ್ಟ್ನಲ್ಲಿ 167 ಸೆಕ್ಷನ್ಸ್ ಇತ್ತು. ಇದರಲ್ಲಿ 170 ಸೆಕ್ಷನ್ಸ್. ಒಂದು 5 ಸೆಕ್ಷನ್ಸ್ ಒಮಿಟ್ ಮಾಡಿದ್ದಾರೆ, ಒಂದು 2 ಸೆಕ್ಷನ್ಸ್ ಹೊಸ್ತು ಸೇರಿಸಿದ್ದಾರೆ. Now I first come to section 1. Section 1 of the Evidence Act or the present BNS, ಭಾರತೀಯ ಹೆಸರಲ್ಲಿ ಸ್ವಲ್ಪ ಕಷ್ಟ, ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮ, ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮ. As you read this, you will find that this is a old wine in a new bottle with flavor and color. Nothing much change as far as Evidence Act is concerned, because in 2002 already an amendment has been made to the Evidence Act, because the information technology had already come in the year 2000. So in pursuance of Information and Technology Act of 2000, already these provisions are incorporated in 2002. Therefore, there is nothing much change in the present act except some small changes which I will point out. Now, I will not deal the unamended portions. Only the amended portions only I will deal. I have prepared a list. A table is there. I have given a copy to the Xerox. You can have a Xerox copy. You will find the old Indian Evidence Act section and one column, the new Bharatiya Sakshya Adhiniyama in the other column, and what are the changes. The minor changes I have made there only. The remaining I will tell you here. First, section 1 has got some change. As you know, normally all the acts are applicable to the whole of India except to Jammu and Kashmir. Now this boundary is removed now. It does not say it extends to the whole of India also. The reason behind is digital India. Now every contract is coming through digital contracts also. So sitting in Mangaluru, sitting in Dubai, sitting in America, and an agreement is entered. That is why section 1 says, in respect of all cases. I'll just read one sentence of section 1 so that you'll understand the change. What is the change? This act may be called as Bharatiya Sakshya Adhiniyama it applies to all judicial proceedings in or before any court. So does not say it applies to India or Jammu Kashmir. So any court. Reason is when a case comes before the court in respect of a contract entered digitally, signed in England and India. So that is why this is taken care. So it does not say it applies to India, it applies to all courts, including court martials. So it applies to court martials also. Navy, ಎಲ್ಲ ಬರ್ತಾ ಉಂಟು. ನೆಕ್ಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್ ಡೆಫಿನೇಷನ್, ಎರಡು ಡೆಫಿನೇಷನ್ ನೋಡಿದ್ರೆ ಸಾಕು ನಮಗೆ, ಬಾಕಿ ಎಲ್ಲ ಚೇಂಜ್ ಆಗಲಿಲ್ಲ. ಎರಡು ಡೆಫಿನೇಷನ್ ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ. ಒಂದು ಡೆಫಿನೇಷನ್ ಆಫ್ ಎ ಡಾಕ್ಯುಮೆಂಟ್. ಡಾಕ್ಯುಮೆಂಟ್, ವಾಟ್ ಈಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ನಮಗೆ ಇಷ್ಟವರೆಗೆ ಗೊತ್ತಿರುವಂಥದ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ರೈಟಿಂಗ್. ಡಾಕ್ಯುಮೆಂಟ್ ಈಸ್ ಎನಿಥಿಂಗ್ ರಿಟರ್ನ್ ಡಾಕ್ಯುಮೆಂಟ್. ಇಲ್ಲಿ ಎ ಡಾಕ್ಯುಮೆಂಟ್ ಈಸ್ ಡಿಫೈನ್ಡ್ ಟು ಇನ್ಕ್ಲೂಡ್ electronic and digital records. So definition document says the document includes electronic and digital records. ಇನ್ನೊಂದು ಡೆಫಿನೇಷನ್ ಇದಕ್ಕೋಸ್ಕರ ಮಾಡಿದ್ದಾರೆ, that is evidence. ಎವಿಡೆನ್ಸ್ ನಲ್ಲಿ ಕೂಡ ಇಲ್ಲಿ ಈ ರೀತಿ ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ. I will, because we have to verify both evidence. Evidence nalli earlier section 2 prakara all statements which the court permits or request made before it by witness is evidence. Now in view of the digital, this is what is the change. All statements, including statements given electronically, is evidence. So electronic evidence, electronically video, audio ಎಲ್ಲ ಕವರ್ ಆಗ್ತಾ ಉಂಟು. ಸೊ ಆಲ್ ಎವಿಡೆನ್ಸ್ electronically. ನೆಕ್ಸ್ಟ್ ಎವಿಡೆನ್ಸ್ನಲ್ಲಿ ಓರಲ್ ಮತ್ತು ಡಾಕ್ಯುಮೆಂಟ್ರಿ. ಸೊ ಸೆಕ್ಷನ್ 2ನಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ರಿಗೆ ಏನು ಹೇಳ್ತಾ ಇತ್ತು, ಆಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ ರೆಕಾರ್ಡ್ ಪ್ರೊಡ್ಯೂಸರ್ ಅಂತ ಇದ್ದದ್ದು ಮೊದಲು. ಈಗ ಅಟ್ ಪ್ರೆಸೆಂಟ್ ಆಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ electronic or digital records. So these two definitions cover the latest technology, that is digital and electronic record. Before I move on to the other aspect, let me just tell you what is meant by digital and electronic. Is there any difference? Yes, because we have Information Technology Act. Information Technology Act ಪ್ರಕಾರ ಡಿಜಿಟಲ್ ಅಂದರೆ ಏನು? Digital record are that can be viewed on computer screen, laptop, mobile, tablet. So digital evidence is evidence available in your computer screen, laptop, mobile. All these are digital. What is electronic record? Electronic refers to information stored in digital format, includes numeric, graphic, audio, video, textual information. So audio, video ಎಲ್ಲ ಕವರ್ ಆಯಿತು. So this is the effect of evidence and documents. Then the next change which I would like to inform, definition, these only two definitions are changed. The next section which I am referring is section 4 of the present act. Earlier section was 6. Section 4 of the present act deals about because without going through these books it is not possible to explain also. So section 4. Section 4 says, facts which though not in issue are so connected with a fact in issue. Earlier, the facts so connected in fact in issue was relevant. Now one more word is added, that is fact in issue or a relevant fact. So, a fact though not in issue which is so connected with the fact in issue. Earlier it was like that only, fact in issue connect ಆಗಿರೋದು. ಈಗ one more thing is added, fact in issue or relevant fact. So whatever is connected to fact in issue and the relevant fact is also a relevant fact as far as section 4 is concerned. That is the change here. The next change you will find, because I am not going to go in detail regarding these sections. Next change you will find is in section 6 of the present act. Section 6 of the act deals about motive, preparation and previous or subsequent conduct. Here what is the change? Section 6 ನಲ್ಲಿ change, ಕೆಲವು ಚೇಂಜಸ್ ಏನು ಅಂತ ಹೇಳಿದರೆ, ಒಂದು ಮ್ಯಾನ್ ಅಂತ ಎಲ್ಲಿ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಬರ್ತಾ ಉಂಟು, ಮ್ಯಾನ್ ದ ವರ್ಡ್ ಯೂಸ್, ಬೇರೆ ಏನು ಚೇಂಜ್ ಇಲ್ಲ ಇಲ್ಲಿ, ವರ್ಡ್ ಮ್ಯಾನ್. ಸೊ ಮ್ಯಾನ್ ಅಂತ ಹೇಳಿದ ಕೂಡಲೇ ಅಲ್ಲಿ ವುಮನ್ ಯಾಕೆ ಆಗೋದಿಲ್ಲ? ಸೊ ದರ್ಫೋರ್ ಇಟ್ ಈಸ್ ಚೇಂಜ್ ಎಸ್ ಪರ್ಸನ್, ಮ್ಯಾನ್ ಈಸ್ ಚೇಂಜ್ ಎಸ್ ಪರ್ಸನ್. ದೆನ್ ಬ್ಯಾರಿಸ್ಟರ್ ಎಟ್ಸೆಟ್ರಾ ಈಸ್ ಚೇಂಜ್ ಎಸ್ ಅಡ್ವೊಕೇಟ್. Then ravished is changed as rape. So these are the only changes in section 6 is concerned. Moving on, now before I forget, I am required to clarify one aspect also. As far as the applicability of the acts, now many ask me, just first please explain regarding the applicability of the acts, because the Evidence Act, CRPC and IPC are repealed. From today, what is the effect is the question. As far as the Evidence Act is concerned, section 170 makes it very clear that all pending cases as on yesterday, 30th June 2024, are governed by the old Evidence Act and not the new Act. Section 160 makes it very clear, all cases pending as on 30th June 2024. Similarly, in CRPC also, same provision is there. The provision in CRPC is just pointed, 1 minute. Section 531, same provision. As far as criminal cases are concerned, the new act comes into operation from today and all pending cases will have to be tried as per the old CRPC only. Because you will find one chart given by Telangana police today, it makes it very clear. They have given the column, 3 column. One is occurrence of crime, number 2 is the date of registration, and number 3 the act which applies. According to this, if the crime had commenced before 1/7/24 and registered before 1/7/2024, it is IPC and CRPC that are to be followed. So crime committed before 1/7/24, already registered prior to 1/7/2024, IPC and CRPC has to be applied. Similarly, if a crime has occurred on prior to 1/7/2024, registered after 1st July from today, then it is IPC which has to be applied for the offence, and procedure is the present act, that is BNLS. So section, suppose yesterday was 302, today it may be different. So you will be charged only for 302, but procedure is the today's procedure. Third, if the offence is after 1/7/2024 and charged also after 1/7/2024, what is the? It is a BNS and BNLS, new act. So therefore there is no confusion at all. All existing will continue under the previous act. This is as far as clarification is concerned. Now moving on to the amendments, I stop. Section 6 I already referred. Next change you will find is in section 21. Section 21 of the Act admission in civil cases. Admission in civil cases, what is the change? Here the change is only one simple. Earlier the words used were barrister, pleader, attorney, etc. Those are replaced by advocate. This is the only change in section 21. Next section is section 22. This is regarding confession. Here some change is there. Confession, those who are dealing in criminal cases will find that a new procedure is adopted for trying cases of according to section 356 of BNSS. According to section 356, if the accused absconds or if he does not appear, the court will not stop the proceedings. Court will have to continue the case. Notwithstanding the abscond of accused, notwithstanding issue of proclamation against the accused, the court will have to continue the case and try the case. But some section 356 provides certain limitations. What has to be, I will just point out for your reference also, though I am not dealing on criminal side, but I have just pointed out what are the procedure to be followed. It says, section 24 says, a trial of more persons than one held in the absence of accused who has absconded or who fails to comply with the proclamation under section 84 of BNS Act shall be deemed to be a joint trial. So trial, normally what you find? Split up. When the accused is absconded, you split the case and proceed with the trial where the accused are present. Now here it is an important change here. You are not going to split up the case, you continue the case. Now what is the point here? I will just refer section 356. When the trial has commenced or if the accused fails to appear even before that, what is the court which has to do? Section 356 says, then when the person declared as proclaimed offender absconded to evade trial and there is no immediate prospect of arresting him, it shall be deemed to be waiver of right of such person to be present and tried in person. So accused will be losing the right of representing before the court. And what the court has to see, court will have to conduct the trial. One time limit is given here. The trial shall not commence till the lapse of 90 days from the date of framing charge. So we have to wait 90 days after framing of charge. Then issue 2 consecutive warrants to the accused with interval of 30 days. Of course, this is not my subject, I just intervened. Then thirdly, because why I am saying is, this is section 24. This has to be published in National or local daily where the accused is last known to have resided. So last address was in Mangalore. Publish in national or local daily and inform in the place where last known. Next, it says inform the relatives also. He may be having relatives, and it also says inform the friends also, so that the friend will inform, so that the case is pending against you, come. Then affix the information in the house, outer house. In his house, inform it, the case is pending and the trial commences. And also display in the police station within whose jurisdiction he is known to have resided. So this is the step which has to be taken, and he can be tried and as if he is present. If the accused has no advocate, the court will grant advocate. So this is the, and one last the reference is, suppose the accused comes, he has got every chance to continue for cross-examination, etc. And after conviction, he can file appeal only within 3 years from the date of judgment. After 3 years, he will lose his right also. This is as far as this act is concerned. Now moving on to section 24 I have referred. Section 32. 31 and 32. Section 31 and 32 of the present act, relevancy of statements as to fact of public nature contained in certain acts and notification, and relevancy of statements as to any law contained in law books including electronic and digital form. So here the change is anything in digital and electronic form is also covered. So earlier it was on books or papers, etc. Now even electronic. So gazette electronic, law books electronics. So now you have all these citations through websites, all those things. This is all covered by section 31 and 32. Nothing much to explain. Section 31 and 32 refers to that. Now one more section, section 35. Relevancy of certain judgments in probate. You know, a judgment passed by a probate court is a judgment in rem. So section 35 says that the includes one more aspect, that is court or tribunal. Earlier tribunal was not there. Now if it is a competent tribunal is constituted to decide this aspect, even the judgment of a tribunal is also covering under section 35. Earlier it was court only, competent court, district court as far as probate is concerned. Now if a tribunal is constituted anywhere to decide these aspects, remember this only, probate, etc., not any other. So final judgment or order decree of a competent court or tribunal in exercise of probate, matrimonial, admiralty or insolvency jurisdiction, these are covered there. Then we move on to section 39, opinion of experts. Experts. As you know, the previous section also, the opinion of expert is relevant. Now what is added here? Digital. As far as digital and computer is concerned, who is the expert? This section 39 says who is the expert. Section 39 clause 2. According to section 39 clause 2, examiner of electronic evidence. His designation is examiner of electronic evidence, where as referred in section 79A of Information Technology Act. Information Technology Act, section 79A says who is an electronic expert. Examiner of electronic expert. So IT Act. Information Technology Act gives. Now it says the central government will have to appoint. I have made some inquiry regarding this and found that the central government has appointed the experts as far as this is concerned. They are in Bangalore, there is one. I'll just give you. Yes. Digital Forensic Division. Digital Forensic Divisions, NCFLE of Hyderabad is the first lab established. Then 7 central forensic labs are in India: Hyderabad, Kolkata, Chandigarh, New Delhi, Guwahati, Bhopal and Pune. So in these places national central forensic labs are there. Rest of the state capitals, it is the state labs, forensic labs. So there the officer is designated as examiner of electronic records. He is the expert. So if any evidence is required, you have to call him. We will find some lot of hindrance while dealing with the case, because we know when we send this signature for handwriting expert, our experience is that for nearly 2 or 3 years you will not get the report. And you know also how to manipulate the report also. We don't know. So we have to wait. Then this is the expert. Next change which has come in section 52. 52 deals about facts which the court shall take judicial notice of. You already know what the court shall take judicial notice of. Apart from the old provisions, something more is added, something deleted. What is added? Section 52 says, facts which the court shall make judicial note. What is added only I will tell you now. All laws in force in the territory of India, all laws in India, including laws having extraterritorial operation. This is what we are having the problem, extraterritorial. So contract signed in Mangalore by one party, contract signed by another person in England, and a case may come in England or case may come in Mangalore. In such cases, these things will be required. Which law? Normally it is a place of contract, but here the 2 places of contract is there, one in England and in Mangalore. So it can be applied both. Section 52, I said, all laws in force in the territory of India, one. Number 2, what is added? I am not going to what is there in the, what is added, international treaty, agreement, conventions with the countries or countries by India. So you know, so many conventions, international treaties takes place. Our ministers or prime ministers are attending there. So the treaties. Then course of proceedings of Constant Assembly of India, Parliament of India and state legislatures. These are all added facts which the court shall take judicial notice. Something omitted. What is omitted? The old act, as you know, deals the reference of United Kingdom. All those words, United Kingdom, etc., are deleted. So we are not presuming anything held in UK. So these are the presumptions dealt under section 52. Section 54 next. Section 54. All facts except the contents of documents may be proved by oral evidence. All facts except the contents of the documents may be proved by evidence. Earlier, there was a change. What was that? All facts contents of the document and electronic records. So, document and electronic record. Electronic record is omitted here because at other places we will find suitable replacement. Then, section 57. Section 57 deals about primary evidence. You know, primary evidence is the document itself produced before the court for proving. This section 57 adds 4 explanations to show what is primary evidence. Apart from the existing definition of primary evidence regarding the documents, etc., 4 illustrations makes it very clear that the digital thing is covered here. What are those sections? Now you will find. Explanation number 4. Explanation 1, 2, 3, all the previous one. Explanation number 4. Electronic or digital record is created or stored, and such storage occurs simultaneously or subsequently in multiple files. Each file is primary evidence. So, digital record stored in multiple records. Each file is primary. I can produce any one. Explanation 5. Where an electronic or digital record is produced from proper custody, such electronic and digital record is primary evidence. So it is not secondary, it is primary evidence unless it is disputed. Explanation 6. Where a video recording is simultaneously stored in electronic form and transmitted or broadcast or transferred to another, each of stored recording is primary evidence. Now I will give an example and will proceed further. We use this mobile now. Everywhere we go, we will take photo or we will record video. So by chance while going, I see an incident where a person is going to murder another. Yes, I have an opportunity, I will record it, video. If I record it, it becomes an evidence if I submit to the police. How it has to prove, I will explain it later with reference to section 63. This is what is the effect. So this is an evidence. Whatever recorded is a primary evidence. If I copy it to somebody, it is not primary, it is secondary evidence. Explanation 7. Where an electronic or digital record is stored in multiple storage spaces in a computer resource, each such automated storage, including temporary files, is primary evidence. Now, as far as, before I just forget, now as far as this computer technology, digital technology is concerned, many of us are illiterates. It is very fair that I also do not know much about this computer knowledge. The youngsters, today's youngsters are better equipped because they deal with this. And even this IT Act was not a subject for us in colleges. We have not studied it. I think present whether it is included, IT Act. So this is what is the primary evidence stated here. So 4 explanations make it clear that electronic or digital record are also primary evidence. Secondary evidence. Secondary evidence, section 58. three things are added here. Apart from certified copies, etc., etc. Clause 6, oral admission. Oral admission is considered as secondary evidence. Clause 7, written admission is also considered as secondary evidence. Number 8, evidence of a person who has examined the document, the original of which consists of numerous accounts or other documents which cannot be conveniently examined in court. Thousands of documents, voluminous records. If you bring this, it will be a lorry load of document and the court has no time. Let us say the chartered accountant examines it. The evidence of chartered accountant, evidence who examines, is secondary evidence. This is the change as far as. Then we move on to section 61. Section 61 is a new section. Electronic or digital record. It says, nothing in this adhiniyama shall apply to deny the admissibility of an electronic or digital record in the evidence on the ground that it is an electronic or digital record, and as such record shall, subject to section 63, have same legal effect, validity and enforceability as other document. So according to section 61, new section, evidence in digital form or electronic form is evidence as if other documents are. For example, you produce one sale deed. Same way, the electronic evidence, if it is produced, is also evidence equivalent to the original sale. How to prove and how to examine is the question next. So this is electronic evidence, is electronic and digital record. Now special provision as to evidence to relating to electronic record, section 62. How to prove electronic record? Section 62 says the electronic records will have to be proved in accordance with section 63. This is section 65B certificate, which you all know, because already in the year 2002 the amendment has made to section 65 to include section 65A and B. Section 65B is section 63. Now you will find one tricky situation here. As far as certificate, with how the certificate will have to be produced, how it has to be relied. According to section 63, there is some clarification which is required by the Supreme Court, because you will find section 65 almost repeats section 65B. So therefore I don't want to explain section 63 in detail, as you know what is section 65B. But how the certificate has to be given, I will explain. According to, before that, there are two important judgments of Supreme Court on section 65B, which will be definitely applicable to section 63 also. One is the latest, Arjun Pandit Rao Kotkar versus Kailash Kushan Rao Gorantial and others, that is reported in I will point out the ruling also. The earlier one, which is approved by this judgment, is Anwar PV versus PK Bashir and others. Both these cases are election disputes, and electronic evidence was given, and the court has to consider about section 65B, how section 65B has to be relied. The latest judgment, because there were divergent opinion by the Supreme Court as far as this case is concerned. One judgment says section 65 is not mandatory. You can rely without section certificate. The other ruling says section 65B certificate is mandatory. The latest judgment says it is mandatory. With this background, I'll find out what is the certificate which you are required to prove. Section 65, section 63, section 63, clause 4. In any proceeding where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things shall be submitted along with the electronic record. Now, earlier regarding the time of filing certificate was not there. Earlier law, Evidence Act, did not specify exactly when you are required to produce the certificate. You could produce certificate at a later stage also. But the present Act specifies the following things shall be submitted along with the certificate, along with the electronic record. So a certificate has to be given along with the electronic record. Certificate to be signed by whom? Signed by a person in charge of computer or communication device or management of the relevant activities, whichever is appropriate. So person who is operating the computer or person in charge of the office, I am the head of the institution, I will certify that this computer is under my control and it is true. Or the person, because you will find a computer system in court, everything video, CC camera is there, everything is there. So if anything happens in the premises court, who has to give the certificate? Is it the district judge who has to require, or the person who is in control, that is taken care? Earlier it was not there. Earlier the person in charge. Now this is what it says, signed by a person in charge of the computer or communication device or management of relevant activities. Remember, one change, important change here is this, and an expert shall be evidence of any matter stated in the certificate. So apart from the party giving certificate, a certificate has to be given by an expert. Who is an expert? I already said who is an expert according to section 79 of the IT Act. This is going to have some problem for us. As far as criminal cases concerned, you may not find the problem because it is the police who will be investigated. Well, before filing all the charge sheet, the police will make all investigation, will take all these certificate from the relevant persons. As far as we are concerned, private persons are concerned, in civil suits are concerned, it is very difficult for us to get a certificate. How to get a certificate? So certificate, so you are having a CC camera in your house. You will not give the certificate. When I ask, yes, an accident takes place in front of your house and I want a proof, direct proof, CC camera proof. I come to you, I will take a print and I request you, sir, give a certificate for me. No, I will not. Without certificate, I cannot produce this. So that is the reason this section 63 may have some problem. And this certificate has a format now. A schedule is given. This is, if you have the act, with you, turn to the end, you will find a schedule. Schedule. This schedule has got two parts, part A and part B. Part A to be filled by part T, part B to be filled by expert. Of course, you will find what are the requirements. I will tell. At the end, I state the hash value of the electronic record is obtained through the following algorithm. Can anyone know what is the hash value? Have you studied this? This is a new concept. When you produce this under IT Act, it is there. Information Technology Act deals about this hash value. So we have to study it now. How to obtain hash value of a file. For your reference, I have just made one study how to find out. This is how you have to generate hash value from computer. Use Windows PowerShell. You have Windows PowerShell. If you can't use computer, you will find a PowerShell. Use Windows PowerShell to calculate the hash value. Open the Windows PowerShell. This is a step you have to follow. Open the Windows PowerShell. Number 2, type get file hash value of what? A file. Then number 3, drag the downloaded zip file onto the Windows PowerShell. So take this file to the Windows PowerShell and press enter. You will get hash value. It may sound easy for us, but I don't know. I tried yesterday, but I could not. Maybe my expertise is not there, probably. Then compare the calculated hash value with the original value. Why this hash value? Any change in a message changes the hash value. Alteration. So you find the hash value, you can read hash value. It looks like this. Hash value ಇಲ್ಲಿಂದ ಇಲ್ಲಿ ಇಷ್ಟು ದೊಡ್ಡದು. ಹ್ಯಾಶ್ ವ್ಯಾಲ್ಯೂ ಇಲ್ಲಿಂದ ಇಲ್ಲಿವರೆಗೆ ದೊಡ್ಡದು ನಂಬರ್ಸ್ ಎ ಬಿ ಸಿ ಡಿ ಈ ತಗೋದ್ರೆ 20 AB1 C2 EE19 ಲೈಕ್ ದಟ್ ಇಟ್ ಗೋಸ್. ದಿಸ್ ಈಸ್ ದ ಹ್ಯಾಶ್ ವ್ಯಾಲ್ಯೂ. ಒಂದು ಸಡನ್ ಕರೆಕ್ಷನ್ ಮಾಡಿದ್ರು ಇದು ಚೇಂಜ್ ಆಗಿದೆ. So this is what we are required to put in the certificate, and this will have to be certified by the expert. Whether what we have said is right or not, certificate has to be given by the expert. That is why I said this certificate has to be explained by the Supreme Court one or another day, whether both are compulsory or one is compulsory. Because as on today, I am unable to clarify this aspect fully unless a judgment is given by the courts. This is regarding the certificate. Now what the certificate should contain? Moving on. So section 65B you already studied what it has to contain. Same thing. Section 63 also says these are the certificate. Yes. I will just point out the conditions found in this section 65. One, the computer output containing the information was produced by the computer or communication device during the period over which the computer or communication device was used regularly to create, store or process information for the purpose of any activity. So the computer must be regularly activated. Number 2, during the set period, information of the kind contained in the electronic record was regularly fed. Next, throughout the material part, the computer was operating properly. So if it is not operating properly, then you have to say that during that period there was no damage at all. Say for example, your computer got spoiled, it was for repair. During that period there was no effect to the digital or these electronic records. Clause D, information contained in the electronic record are done in the ordinary course of the said activities. These are the things. One more procedure is adopted. When you say computer, here clause 3 of section 63 says where number of computers are involved. In a where over the period the function of creating, storing or processing information for the purpose of activity regularly carried on over the period as mentioned in clause A of section was regularly performed by means of one or more computers or communication device where in a standalone mode, that is single, or on computer system or computer network or a computer source. So these are all covered. So all computers and communication devices used are considered to be single computer. So in your office there may be 4 or 5 computers you having connection to one another. All these are considered to be single computer for this. Now I have referred this judgment of Supreme Court regarding the certificate. 1 or 2 reference has to be made here, because the earlier judgments of the Supreme Court, some judgments of the Supreme Court said certificate under section 65B was not mandatory in all ways, because in many cases a certificate is very difficult to be obtained. The latest judgment of the Supreme Court says no, it is the court's duty to get the certificate. You exhaust your remedy. If the certificate is not available, you ask your friend, give me a certificate. He is not giving. You have to file an application to the court to summon the person. As per CPC order 16 and as per CRPC, as per the relevant provision. File an application. Insist the court to summon the person to give certificate. Then only you can say certificate is not available. Otherwise, certificate is mandatory. This is what said. So this is regarding the certificate is concerned. Change is in section 73. Section 73, proof as to verification of digital signature. Section 73, proof as to verification of digital signature. In order to ascertain whether a digital signature is that of a person by whom it purports to have been affixed, the court may direct that person or the controller or the certifying authority to produce the digital signature certificate. So we can rely upon digital signature certificate by summoning the experts. IT Act provides for that how the digital signature will have to be obtained. There are 2 keys, one is private key, one is public key. Private key is in the control of the person who makes the signature. Public key is available to all the public. Now, we have experienced one problem the other day regarding marking of certified copy of a sale deed. Recently, what you know, the certified copies of sale deeds are only documents from registration office. Where you are getting? From your office computer. You need not go to the registration officer to get the certified copy. You produce this certified copy from your office computer and say mark it. One judge says, no, you have to produce certificate. I don't want to name. He said, no, it is an electronic certificate. Not necessary to give certificate for that because it is a procedure prescribed for issue of certificate. What best I can give certificate? I can only give certificate saying that this certified copy is printed from my computer through the process involved. That's all. I have made an application, I have paid all these things according to the provision. I have printed from my computer. That is the certificate, best certificate available. You can give certificate. So this is how this evidence can be given. Next, section 74. Section 74, public and private documents. Of course, you will find only one section which is retained by the old act and present act, section 74, public document. All other sections are changed. Numberings change. Remember, the old act, evidence act, and the present act, numberings are totally changed. There is a schedule prepared by me on the basis of a book. I have made one extra column here. Where is the change and what change? The very short changes I have just noted there only. I have given one set with our Xerox person. If you want, you can have a Xerox copy of this. You will find in short what is old section, what is new section, and what are the changes made. Short only it will find. Section 7, which one I was referring? Section 74. Yes, section 74, public document. Earlier also section 74 reusable public documents. What is the change? In section 74, the previous section, Commonwealth was there. So all these words, Commonwealth, etc. are omitted because it is all the British domain is to be omitted. You will find number of these things. Commonwealth, England, UK, these are all omitted. Barrister, wakils, all omitted because it is Indianization, digital India. Next is section 77. Proof of official document. Here also, Crown representation, Her Majesty, Queen's printer, these are all omitted. There is no other change except these designations. Section 78 deals about presumption as to genuineness of certified copy. So, certified copy if it is produced to the court, it has to be presumed. What is the change here? Only change is Jammu and Kashmir is omitted, that's all. Because of the change in India, Jammu and Kashmir is omitted, that's the change. Section 80, presumption as to Gazette newspaper. Here also, the change is London Gazette is omitted. So, London Gazette. Next is section 81. Section 81 deals about presumption as to gazettes in electronic or digital record. Now earlier the gazettes were in book form. Section 81 takes care of gazettes in electronic and digital form also. Apart from the book form, gazettes published in books, apart from that, gazettes in electronic and digital records are also presumption is there. Section 82, presumption as to maps and plans made by authority of government. Section 80, there is no change there, anyhow, no change. Section 88, Section 88, presumption as to certified copies of foreign judicial records. Here also, Her Majesty, domination, etc. omitted. Here one addition is there, certified copy of any judicial record of any country beyond India is also to be presumed as genuine. So certified copy produced from UK or America, whatever country you produce it, the court shall presume that it is genuine. Then section 90, presumption as to electronic messages. You will find so many messages electronically, SMS, all these messages. Here, what is the presumption? Section 90 says, the court may presume that an electronic message forwarded by the originator through an electronic mail server to the addressee to whom the message purports to be addressed corresponds with the message as fed into his computer. So now I send a message to you from my computer to you. Section 90 says there is a presumption that what is received by you is what is sent by me. So presumption as far as electronic, unless it is tampered, it is always possible to tamper. This is address correspondence with the message as fed into his computer for communication, but the court shall not make any presumption as to the person by whom such message was sent. So presumption is in respect of the message only, not regarding the person. Then section 92, this is the old section 90, presumption regarding 30-year-old's document. Only old explanation is omitted because it says explanation made in section 80 is made applicable. Section 80, there is one explanation. Explanation in section 80. For the purpose of this section and section 92, a document is said to be in proper custody if it is in the place in which and looked after by the person with whom such document is required to be kept. Now let us say the Tahsildar or Assistant Commissioner or DC. What is their duty? They have got the duty to preserve these, let us say, certain document. It presumes that this is a certificate issued by the Tahsildar or DC accordingly. This is presumption as to electronic documents. One more section is section 93, presumption as to electronic records 5-year-old. There the old explanation 90A is omitted. Explanation in section 81 is again stated. What is explanation 81? It also says the custody. Custody, from proper custody. Next is section 122, estoppel of tenant. We already studied that a tenant cannot dispute the title of the landlord during the pendency of his tenancy. What is the change here? Section 122 makes a change. It says during the continuance of lease and even thereafterwards. So, tenant cannot dispute the landlord's title even after he ceases to be a tenant. So, I can't say, no, you are not my landlord when you gave me the property, even during the pendency or even thereafterwards. So, this is the estoppel of tenant. Then, section 124. Who may testify? All persons capable can testify. What is the change? In old section, the word used was lunatic. That is changed as person of unsound mind. So lunatical, instead of lunatic, it is person of unsound mind. Then section 132, professional communications. Communications between client and advocate. You are not supposed to. What is the change? Change here is words barrister, attorney, pleader, vakil, etc. are removed to advocates. All these barrister, etc. all British. So we are not barristers, we are only advocates. So that is what is the change. Section 133 also says the same thing. Word barrister, etc. are removed and only advocates retained. Section 134, confidential communication with the legal advisors. If the client communicates confidentially saying that I have murdered so and so, please do something for me. Confidential communication. What it says, this confidential communication with the legal advisor, this word used in section 1, earlier section was legal professional advisor. It is changed as legal advisor, that's all. Nothing is changed. Only word legal professional advisor is changed as legal advisor. One more section 138 applies to the criminal case. Accomplice. Old section 133. An accomplice shall be a competent witness. Whether on the statement of accomplice conviction can be made is a question involved in section 138. What was the old section 133? According to old section 133 of the Evidence Act, conviction is not illegal merely because it proceeds upon uncorroborated testimony of accomplice. Conviction is not illegal merely because it proceeds upon uncorroborated testimony of accomplice. So, the court has decided the case without corroboration of the statement of accomplice. Now the change in section 138. An accomplice shall be competent witness against the accused person and the conviction is not illegal if it proceeds upon corroborated testimony. So, corroborated testimony of accomplice supported. If the conviction is based on the corroborated testimony of accomplice, conviction is not illegal. So that is a change. So 133, conviction is not illegal merely because it proceeds upon uncorroborated testimony. Now change is, it is not illegal if it proceeds upon the corroborated testimony. So this is a change. Next section 152, question not to be asked without reasonable ground. In cross-examination we will ask so many questions without any ground. Same thing continues here, 152. But what is amendment? Barrister replaced by advocate. That's all. Section 165, change. when a person is summoned to produce original document. Normally, when the court summons original document, you are bound to produce it. If you have got any objection, you can write objection saying why you can't produce. Section 165, there is a change. Notwithstanding an objection for production, the person summoned shall bring the document to the court. He has to bring the document to the court and show it to the court, not to the parties, and the court will have to decide what is the objection. If the court upholds the objection raised by the witness, yes, it will not be referred. If the court says no, the objection is not justified, the court will refer the document overruling the objection. With this, I come to the last section, section 170. I have already touched it at the beginning. Once again, section 170 is repeal. Repeal, what it says? Section 170 says, Evidence Act is hereby repealed. Notwithstanding the repeal, all cases pending in trial, in appeal, shall continue with the old Evidence Act only, as if the new Adhiniyama has not come into force. That means any case filed from today, you will have the new Adhiniyama and not the old Evidence Act. Any suit filed today, you have to follow the new Adhiniyama. Any suit filed till 30th June 2024, follow the old Evidence Act only, follow the procedure. Any appeal pending, I'll just read that section and close it. Section 170, the Indian Evidence Act is hereby repealed. Notwithstanding such repeal, if immediately before the date on which this Adhiniyama comes into force, there is any application, trial, inquiry, investigation, proceedings, appeal pending, it covers the appeal also pending, then such application, trial, inquiry, investigation, proceedings or appeal shall be dealt with under the provisions of the Indian Evidence Act as in force immediately before such commitments, as if Adhiniyama had not come into force. This is also as per Section 6 of General Clauses Act. Section 6 of the General Clauses Act takes care of this repeal. If the Act is repealed, whatever done earlier, whatever continued will be continued. I will give an example. Today, of course, in a criminal case, today the Act is new. Yesterday, the Act was old. As on today, sedition, I think, is an offence. Yesterday, it was not so. If yesterday you are booked under this sedition, you are not governed by the present Act, but you are governed by the old Act. So you can't be prosecuted under the new Act to say that you have committed this. So same way, these are the changes as far as the Act is concerned. So with all the provisions, you need not worry for the time being, because this matter will be set at right when the appeal comes to be disposed of by the courts. Till then, we will have the old Act in force. Thank you for having listened me patiently. Thank you. Not teach the Evidence Act so far. This is the first time probably I have touched this Evidence Act. Therefore, I can't answer the questions in relating to the Evidence Act. I only
ಏನಾದರೂ ಪ್ರಶ್ನೆ ಇದ್ದರೆ ಕೇಳ್ಬೋದು. 2 ನಿಮಿಷ. ಅಲ್ಲ ಇವತ್ತಿನ ಅಧಿನಿಯಮದ ಬಗ್ಗೆ ನಮಗೆ ಸವಿಸ್ತಾರವಾಗಿ ನಮ್ಮ ನೆಚ್ಚಿನ ವಕೀಲರು ಸೀನಿಯರ್ ಆಗಿರುವಂಥ ಶ್ರೀಯುತ ಪ್ರೇಮನಾಥ್ ಸರ್ಗೆ ನಿಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ಹೃತ್ಪೂರ್ವಕವಾದ ಧನ್ಯವಾದಗಳು. ಹಾಗೆ ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ನಿರ್ವಹಿಸಿಕೊಟ್ಟಿರುವಂಥ ಮಂಗಳೂರು ವಕೀಲರ ಸಂಘದ ಅಧ್ಯಕ್ಷರು ಹಾಗೂ ಪದಾಧಿಕಾರಿ ಅವರಿಗೂ ಕೂಡ ಹೃತ್ಪೂರ್ವಕವಾದ ಧನ್ಯವಾದಗಳು. ಈ ಒಂದು ಕಾರ್ಯಕ್ರಮ ಸುಂದರವಾಗಿ ಆಗಬೇಕಾದ್ರೆ ನಿಮ್ಮೆಲ್ಲ ಪ್ರೆಸೆನ್ಸ್ ತುಂಬ ಅಗತ್ಯ. ನೀವು ತಾಳ್ಮೆಯಿಂದ ಕೇಳಿರುವಂಥ ಎಲ್ಲ ವಕೀಲರು ಮಿತ್ರರಿಗೂ ಕೂಡ ಮಂಗಳೂರು ವಕೀಲರ ಸಂಘದ ಪರವಾಗಿ ಹೃತ್ಪೂರ್ವಕವಾದ ಧನ್ಯವಾದಗಳು.